Welcome to our video on Secretarial Audit and Secretarial Auditor under Section 204 of the Companies Act 2013 and its Rules 9 including amendment. Regulation 24A of SEBI LODR 2015, SEBI Master Circular, Detailed Analysis. We are aiming of details, dive deep analysis of the topics. We shall divide the topics in three parts for better understanding the topic. Detailed analysis. The video shall divided into three parts comprising of first part, we understand the Section 204 Companies Act 2013 and its Rules 9 of the Companies Appointment and Remuneration of Managerial Personnel Rules 2014, accompanied by the template form number MR3 prescribed under the rules. Under second part, we shall under the Regulation 24A of SEBI LODR 2015, including SEBI Master Circular dated January 30, 2026, prescribing the templates therein. And in third part, the procedure to be followed by the Company Secretary. Further, our video will be oriented with practical way approach. Therefore, to understand the easiest way, in order to understand the topic is more detailed practically way, we shall take examples. That suppose I am Company Secretary and Compliance Officer of the listed company known as Safar Aur Seekh Limited, wherein our audit committee given me task, me to initiate the process of inducting the Secretarial Auditor, hereinafter referred to as assignment. As the Company Secretary, before apprising the audit committee and thereafter to the Board of Directors, I will initiate to ascertain all the relevant provisions and procedures that will be applicable for the said assignment in details. Accordingly, I had chopped some of the provisions in the next slide as I needed to comply as CS for successful concluding the said assignments. Relevant sections, rules, forms, Ministry of Corporate Affairs Amendment and SEBI LODR and SEBI Master Circulars at a glance. Now we move on to first part. We will understand the Section 204 Companies Act 2013 and its Rules 9 of the Companies Appointment and Remuneration of Managerial Personnel Rules 2014, including amendment made thereto, accompanied by the template form number MR3 prescribed under the rules. Question 1. Which companies are required to appoint a secretarial auditor and what are the prescribed criteria? Answer. Pursuant to Section 204 of the Act read with its rules, 9 of the Company's Appointment and Remuneration of Managerial Personnel Rules 2014 has listed down the below company needed to induct the Secretarial Auditor. All listed companies are mandatorily required to conduct secretarial audit except SME listed company pursuant to Regulation 15(2)(b) of SEBI LODR, Regulation 2015. 2. Public company. Public companies meeting any of the following criteria. A. Paid up share capital of 50 crore rupees or more, or B. Turnover of 250 crore rupees or more. 3. Other companies. Any company having outstanding loans or borrowings from banks or public financial institutions of 100 crore rupees or more. Question 2. Is any format template prescribed for furnishing the secretarial audit report? If yes, where is it required to be attached? Answer. Yes, a specific format is prescribed for the secretarial audit report. For public companies and other applicable companies, excluding listed entities under LODR framework, pursuant to Section 204 of the Companies Act 2013, read with Rule 9(2) of the Companies Appointment and Remuneration of Managerial Personnel Rules 2014, the Secretarial Audit Report must be prepared in Form MR3. Further, as per Section 134(3) of the Companies Act 2013, the Secretarial Audit Report in Form MR3 is required to be annexed to the Board's report in case of public companies and other applicable companies in accordance with the provisions of the Companies Act 2013. However, in the case of listed companies, the reporting requirements are governed separately by Securities and Exchange Board of India, SEBI, which prescribes a different format for compliance reporting, that is, Secretarial Compliance Report, under its Master Circular and applicable regulations. The Board of Directors must provide explanations or comments on any qualifications, observations, or remarks made by the Secretarial Auditor in the report. Question 3. Who are liable under Section 204? What is the penalty for non-compliance with Secretarial Audit provisions under Section 204? Answer. As per Section 2044 of the Companies Act 2013, if a company or any officer of the company or the company secretary in practice contravenes the provisions of this section, the following persons shall be liable: the company, every officer of the company who is in default, the company secretary in practice, secretarial auditor. Penalty amount. Each such person shall be liable to a penalty of 2 lakh rupees as per recent amendment substituted by the Companies Amendment Act 2020. Notification dated 28 September 2020. Amendment effective from 21st December 2020. Now we had reached to conclusion of the part 1 of these topics. Thank you for watching. Please like and subscribe to our channel to stay updated with our latest content.